Hi everyone and welcome to another Bernitsa's Law podcast. My name is Pelina Leontiadou and I'm here with my colleague Venaki to discuss legal developments covering assisted reproduction, an issue that touches many families and especially women.
Thank you, Pelina, and thanks for the introduction. Before we get to the legal framework, let's take a moment to reflect on the historical context. Let's go back to the early 20th century when one of the first female lawyers, Maria Flaburari, worked on the preparation of a draft law with a protective social nature. This law, entitled On Paternity and Protection of Illegitimate Children, aimed to address a pressing social problem at that time. This was the social stigma faced by women giving birth to children outside marriage and in this way creating unconventional families. Coming to today, we have seen significant progress in this area. While it's true that not all jurisdictions offer the same level of protection for single mothers, we can say with certainty that Greek legislation has evolved to ensure a good level of protection for single mothers and, most importantly, for children born and raised by single mothers, even in cases where the father's identity is unknown.
This is true, there has been significant progress, and today, fortunately, having and raising a child without being married is no longer seen as an unfortunate event. On the contrary, it is a viable and respected option which is supported by legislation. Now, coming to the main theme of today's discussion, assisted reproduction, it would be interesting to note that this first started in Greece in 1982. At the time, no legal framework existed, so the practice was effectively self-regulated. It took 20 years for the first Greek law to be enacted in 2002. This was Law 3089 of 2002. It is often said, and it is true, that this law was one of the most progressive of its time. It introduced scientific solutions and made certain choices available for issues which are still controversial in many countries today, such as post-mortem IVF. Over the years, the legislation continued evolving, with a milestone being Law 3305 of 2005, which was further amended in 2018 and 2020, and more recently 2022, by Law 4958 of 2022, which modernized and expanded the legal framework.
You are right. Assisted reproductive technologies have come a long way, and legislators are adapting. As you said, Greek legislation on medically assisted reproduction is considered one of the most progressive in Europe. The legislation consists of several laws, presidential decrees, and ministerial decisions that also adopt EU directives into Greek law. I wanted to focus on the main legislation and the key institution in this framework, the National Authority for Medically Assisted Reproduction. Some critical areas the authority regulates concern donors of genetic material, the requirement for pre-implantation testing, surrogacy, clinical and laboratory testing of sperm and eggs donors, the number of fertilized eggs which can be transferred together, and the application of methods of assisted reproduction to HIV-positive persons.
This is a very complex issue, both legally and medically. But before going into details, let's start from the basics. What exactly is medically assisted reproduction? Who can undergo the procedure? And does the law set any limits?
Sure. Medically assisted reproduction, commonly known as IVF, is a very complex procedure involving various methods of fertilization, such as with the use of donor sperm and eggs, donated embryos, and surrogacy. However, the most common way IVF is used is to help individuals or couples who are having difficulty conceiving naturally. It is a complicated and ethically sensitive procedure, and so the law imposes a series of limitations on various issues, such as an age limit of 54 for women and a requirement that women between 50 to 54 years old seek permission from the national authority. Minors are not eligible for IVF except in specific cases where there is a risk of infertility due to a serious disease which can lead to infertility, either in itself or following treatment.
And what about assisted reproduction units?
Well, the national authority grants licenses for the establishment and operation of medically assisted reproduction units. They can be legal entities operating both under public and private law and must include health services in their statutory scope and comply with the rules of medical science and ethics. Individuals can also establish and operate units provided that an obstetrician gynecologist is appointed as scientifically responsible for the unit. Units are closely monitored and controlled by the national authority, to which they submit yearly reports. They need to have a backup and independent power supply and comply with an applicable occupational, health and safety and waste management legislation.
Another thing the law underlines is that the scientific personnel of these units must be clear about the social, ethical, legal, and economic consequences of applying assisted reproduction methods. Providing detailed and clear information is very important, as this is the basis on which patients can give their full and valid consent to the assisted reproduction procedure they are undergoing.
Absolutely. The national authority is responsible for deciding what information must be included in the information and consent forms. These forms are filed with the units and kept in the medical file of the individuals or couples undergoing IVF. So it's all about ensuring that everyone involved fully understands the process and gives their informed consent, making the whole procedure transparent and trustworthy.
I would also like to stress an aspect of the current law, which I consider to be major for the recognition and protection of a person's freedom to reproduce. The fact that single women are given the choice to have children using a donor. This would be unheard of only a few decades ago, and this is a great example of how Greek law has kept up with social change. The law does, however, set strict conditions on who can become egg and sperm donors and in what circumstances.
Yes, this is correct. The legislation provides that donors must be adults with full legal capacity, sperm donors must be under 40, and egg donors under 35. There are, of course, some deviations from this age limit in certain cases, but a decision by the national authority is required. Donors are subject to medical testing and are not accepted if they suffer from hereditary, genetic, or contagious diseases, while untested sperm from a third-party donor cannot be used. The health data of donors is kept completely confidential, encoded and stored with the Cryopreservation Bank and the National Register of Donors and Recipients.
A recent and interesting addition brought in by an amendment to the law in 2022 is that donors can choose whether to be anonymous and also whether their identity is revealed if children born using their genetic material request this after they become adults. However, donors don't get any information about the identity of the child or its parents.
Yes, and other important issues the regulator has considered include the number of children born from the same donor, which could give rise to ethical and medical issues. For example, it could increase the possibility of children who are siblings through donors meeting and having children. So the law sets a limit of 12 successful fertilizations from any one donor, with limited exceptions. Donors are not permitted to receive any form of compensation for providing sperm, eggs, or fertilized eggs for use in IVF, but they can be reimbursed for medical, laboratory, and hospitalization expenses. They can also be reimbursed for travel and accommodation costs and income loss due to absence from work while undertaking the procedure. The amount which can be reimbursed to donors in terms of costs and expenses is determined by the national authority.
And coming now to surrogacy. This is an option, but it involves a third person and poses many legal, ethical, bioethical, and economic concerns. This is why the regulations surrounding surrogacy have been one of the most discussed issues of our time, and even as we speak, a new amendment of the current law is underway.
Yes, you are correct. This is an option for couples, but also for single women, where there are health issues which prevent a woman either from conceiving or carrying to term. Surrogacy offers a solution in these cases, and people wishing to have a child through surrogacy must do so through a unit only and with permission obtained from court. A surrogate is a woman who agrees to carry and give birth to one or more embryos created through IVF procedures, with genetic material, however, which is not her own. Two important notes here. First, Greek law strictly prohibits the use of the surrogate's eggs in the process. And secondly, the surrogate has no relationship with the baby she gives birth to. The newborn is a child of the IVF parent or parents, and adoption procedures are not required.
Surrogacy is available to both Greek and foreign residents, heterosexual couples who are married or in a free union, single women, and same-sex female couples. The position in relation to single men and same-sex male couples is not yet clarified, and actually this is being discussed in the context of the amendment to Law 4958 of 2022 that, as I said, is currently underway. Perhaps this could be an issue for another podcast, so stay tuned. And I think it's worth repeating that surrogacy is permitted only after obtaining permission from the court. The court looks into whether specific requirements are met before granting the permission to proceed with the treatment. So anyone considering surrogacy should seek legal advice.
Yes, Pelina, and I think from our discussion it is clear that the Greek legislator has taken on difficult issues that many of our European counterparts have chosen not to provide for at all.
Thank you all for listening, and thank you, Ria, for the insightful discussion. Navigating the legal landscape of medically assisted reproduction is complex. That is why understanding the legal framework is crucial. If you would like to find out more information about this matter or any other legal matter you may have, visit www.bernitsaslaw.com or reach out to us directly.
This is Bernitsa's Law Podcast, your window to the latest legal developments in Greece. This podcast is intended to provide general information and is not meant to constitute a comprehensive analysis of the matters or to be relied upon as legal advice. It is not meant to create a lawyer-client relationship. Legal and other professional advice should be sought before applying any of the information in this podcast to a specific situation.